What I have for you this week is a number of decisions called the Maruti Suzuki cases from India and the so-called bright line test. And we're going to look at the High Court of Delhi decision from 2010, which started the bright line test in India. And the timing of the decision was quite good because around this time the OECD started working on the intangibles chapter, and they would continue working on that during the BEPS years from 12 through 15. And this case definitely had influence on the OECD because there were not a lot of cases around about marketing intangibles at the time. Then we will also look at the ITAT special bench in Delhi, which dealt with the LG case, which discussed Maruti Suzuki. And then we will come to a 2015 decision of Maruti Suzuki, again of the Delhi High Court, but completely reversing what it said in 2010. And part of the reason why is because of the ITAT decision in Delhi, but also because the Supreme Court reversed part of or all of, that's not clear, the 2010 decision. And then there was also a decision in a case called Sony Ericsson, which discussed the meaning of the Supreme Court decision about the first High Court decision in Delhi. And just it might be confusing as to why are there two cases. Well, the 2010 case dealt with, as you can see here, the years for 2004 and 2005, and the transfer pricing officer made the adjustment for 2004 when he also suggested that it gets rolled out by the assessing officer to the years 2005 and 2006. And if you then look at the 2015 decision, those were two appeals. One was against 2005 and 6, but there was also a second appeal running against 2006-7. I'm not quite sure what happened with the 2004-5 case. Having worked for businesses that have business in India, I do know that the fact that that you win a case in 1 year does not mean that you don't have to litigate the same case again or slightly different case in the next year in India. So let us just, for clarity, you can see here that in the decision there was an adjustment of crores, 200 million or something, and it's just short text on what the different meanings of different numbers in Indian decisions are. A crore is 10 million, and a lakh, as we can see, is 100,000. You come across those in Indian decisions quite often. Well, let's look at the facts of the case, and these were described in 2015 but applied equally to 2010. So MSIL, that is Maruti Suzuki India Limited, is engaged in the manufacture of passenger cars in India. It is a subsidiary of Suzuki Motors Corporation in Japan. As on 31st of March 2006, the SMC held 54.21% of the shares in MSIL. 10.27% of the shares were held by the government of India, and the balance was held by the Indian public and others. So now, and then we get into a bit of history in Maruti, and this is really important for the case. MSIL started its business in 1982 as a government of India owned company. SMC was selected as the business partner independently by MSIL. So MSIL worked with the SMC even before it became a SMC subsidiary. It was actually, considering the fact that MSIL was a business started by the government of India, you can say the government of India has chosen Suzuki as a business partner, right? It is stated that the co-branded trademark Maruti Suzuki was used since the inception of MSIL. In other words, since 1982. A license agreement was entered into between MSIL and SMC in October 82 for its models M800, the Omni and the Gypsy. By said agreement, MSIL was permitted to use the co-branded trademark Maruti Suzuki on the said vehicles. Okay, and what happened there, and you see later in the decisions, is that the Indian economy was pretty closed, I think, until maybe the early 80s. And then it started opening up and started booming into the huge economy that we do know today, right? But as long as the market was closed and protected, Maruti was doing totally fine on itself. It was a large, well-known Indian brand, and it did well. Its cars were maybe a little outdated, but it didn't have to worry about foreign competition, so that was not a problem. As the markets opened up, Maruti realized that it was in trouble, because it now had to compete with Hyundai and Honda and all these foreign brands, and they had far more advanced technology, they had far more spending budgets on marketing, etc., etc. So Maruti decided to partner with Suzuki in order to get some of that technology and to build it into its own cars and to build some Suzuki motors in India. And so it was really a defensive move on Maruti's side to stay in business in the face of the new increased foreign competition in India, right? So if we look at point 6, MSIL filed its return of income for the assessment year 2005-2006 in 2005. The TPO proposed an adjustment of 252 crores. Now see previous slide for what a crore is. To the return income of MSIL. The TPO made an adjustment for 98 crore as regards the royalty paid by MSIL, attributing the same toward for the use of foreign trademark of SMC on the ground that the brand had no value. And what happened was Maruti paid a royalty to Suzuki for both using the brand and making the cars, right? But that was one royalty. And what the Indian tax inspector does, he said, well, of that royalty that was paid, 98 must have been for the use of the Suzuki brand. That brand is totally worthless in India, so therefore that was 98 that should not have been paid. That's what he says, right? The said adjustment was later deleted by the ITAT, and I think the Indian inspector is quite proud of India and quite proud of Maruti, and maybe therefore not so keen on the idea that a foreign brand could be worth more or could have a brighter future than Maruti had itself, right? The remaining adjustment of 154, that is the 252 minus 98 crores, was towards A&P expenses by imputing a notional purported arm's length compensation towards the A&P expenses incurred by MSIL for SMC. So what happened here, we can see what was going on here. The case of MSIL is that while undertaking the above exercise, the TPO on its own benchmarked A&P expenses as advertising, marketing and promotion expenses incurred by MSIL in India. Although that transaction, the international transaction, was not specifically referred to the TPO, and it wasn't referred to by the assessing officer because there was no transaction. This is an imputed transaction, right? The aggregate A&P expenses incurred by MSIL was 204 crores, which constituted 1.87% of its sales. Elsewhere, the court later says that Suzuki by itself on average spent 7.5% of its total turnover on marketing and promotion. So this was actually quite tiny compared to Suzuki. Of this 1.87%, or 204 crore, 162 was advertisement expenses and 42 was towards sales promotion. The TPO, Transfer Pricing Officer, undertook the benchmarking analysis by applying the bright line test and compared the portion of expenses incurred by MSL to that incurred by comparable companies. The TPO compared the A&P expenses incurred by MSIL with a mean of 0.62 incurred by comparable companies being Hindustan Motors, Tata Motors, and Mahindra. Since the ratio of selling distribution expenses as a percentage of sales in MSIL was higher than that incurred by comparable companies, the TPO concluded that the excess must be regarded as having been incurred for promoting the Suzuki brand by SMC. Now, the problem with Hindustan, Tata Motors and Mahindra was that they were totally not comparable. This is what the court discusses later, already in the 2010 case, later in the decision, because I believe one of them, I think Tata Motors, was primarily selling trucks, so that was business to business. Hindustan Motors was, I believe, selling tractors to farmers, and the marketing necessary for that is just completely different from that of passenger cars, which is very status related, which is highly advertised on TV. You don't see thousands of advertisements for farm tractors on television typically, right? So the final order of the TPO, if we look, and this comes back to what I'm saying, that he must have been very proud of India, is in the final order the TPO came to the conclusion that the trademark Suzuki owned by SMC had piggybacked on the trademark Maruti without any compensation being paid by SMC to MSIL. He also came to the conclusion that the trademark Maruti had acquired the status of a super brand. Maybe he had a Maruti himself, whereas the trademark Suzuki was a relatively weak brand. He concluded that the promotion of the co-branding Maruti Suzuki had resulted in A, the promotion of the trademark of Suzuki, the use of the trademark of Maruti by MSIL, the reinforcement of the Suzuki trademark, which was a weak brand as opposed to Maruti in India, and the impairment of the value of the Maruti trademark due to the co-branding process. So the Indian inspector basically ignored the history of Maruti and why it went into business with Suzuki in the first place. A 10-second commercial. If you want to learn more about international taxation. So let us look and see what the court in 2010 actually decided. It came to a number of conclusions and instructions for the tax inspector. First, it said the onus is on the assessee, the taxpayer, to satisfy the TPO that the arm's length price computed by it was in consonance with the provisions contained in section 92 of the Act. So that is the Indian transfer pricing rules, right? And then the TPO and the assessing officer needs to give appropriate notice to the assessee, giving him an opportunity to produce evidence. In case the TPO proposes to make adjustments, he needs to give a notice to the assessee conveying the grounds on which the adjustment is proposed to be made, followed by an opportunity to reply to that notice and produce evidence to controvert the grounds on which the adjustment is proposed. So the taxpayer must have the ability to know that there's an adjustment coming and to argue against that adjustment. And that didn't happen in the initial instance for Maruti Suzuki. If an independent domestic entity uses a foreign trademark and/or logo on its products, no payment to the foreign entity in this regard is necessary unless agreed by it. And that makes sense, right? If an independent party uses a foreign trademark and pays for it or doesn't pay for it, that all depends on negotiations. If a domestic entity, which is an associated enterprise, uses a foreign trademark and/or logo on its products, no payment to the foreign entity on account of such user is necessary in case the use of the trademark or logo is discretionary for the domestic entity. However, if the domestic entity, which is an associated enterprise, is mandatorily required to use the foreign trademark, appropriate payment in this regard should be made by the foreign entity to the domestic entity. In other words, if you say, I have to use your trademark, you need to compensate me for it, on account of the benefit that it derives in the form of marketing intangibles obtained by it from such mandatory use of its trademark. In other words, a little bit what the inspector said, right? If Maruti had to use a Suzuki trademark, then Suzuki should pay Maruti for promoting the Suzuki trademark in India. But the question is how much? And this gets dealt with in the next points. Even in the cases where payments in terms of clause 5 above is to be made by the foreign entity, the arm's length price in respect of the income needs to be determined by taking into consideration all the rights obtained and the obligations incurred by the parties. The expenditure incurred by an independent domestic entity on advertising, promotion and marketing of its products using a foreign trademark does not require any payment or compensation by the owner of the foreign trademark to the domestic entity on account of use of the foreign trademark in the promotion, advertising and marketing undertaken by it. And likewise, the expenditure incurred by a domestic entity, which is an associated enterprise of a foreign entity, on advertising, promotion and marketing of its products using a foreign trademark does not require any payment or compensation by the owner to the domestic entity on account of the use of the foreign trademark in the promotion, advertising and marketing undertaken by it, so long, and this is it, so long as the expenses incurred by the domestic entity do not exceed the expenses which similarly situated and comparable independent domestic entity would have incurred. So this is the bright line test, right? If I don't go further than what my domestic competitors are doing, who may be using unassociated foreign brands like Hyundai or something like that, then I don't need to pay my related party anything, because I'm spending just as much as my competition is. Or if I spend more and I also earn more, I maybe also don't have to pay my foreign related enterprise. If we look at point 9, if the expenses incurred by a domestic entity, which is the associated enterprise of a foreign entity, using a foreign brand, trademark and or logo while advertising, marketing and promoting its products, are more than what a similarly situated and comparable independent and domestic entity would have incurred, the foreign entity needs to suitably compensate the domestic entity in respect of the advantage obtained by it in the form of brand building and increased awareness of its brand in the domestic market. And this was what the tax inspector tried to argue, but he used the wrong comparables, because he used tractor companies and B2B companies, not B2C companies. Point 10, the TPO needs to determine the arm's length price in respect of the international transaction, taking into consideration all the rights obtained and obligations incurred by the two entities, including the advantage obtained by Suzuki, right? In order to ascertain whether the expenses incurred by the domestic entity, which is an associated enterprise, on marketing, promotion and advertising are more than what similarly situated and comparable independent domestic entity would have incurred, it would be necessary to find the appropriate comparables, not the ones that the tax inspector has used. Suitable adjustments will then have to be made, such as if the one company is far more profitable than the other because of higher marketing. And then the court in 2010 concluded, for the reasons given in the preceding paragraphs, the impugned order dated 30/10/2008 is hereby set aside, and the TPO is directed to determine appropriate arm's length price in terms of the provision contained in section 92C, again the Indian transfer pricing legislation, and in the light of the observations made and the view taken by us in this order. So this is what the 2010 decision was about, and this was what became known as the bright line test. However, the Indian tax authorities appealed the decision to the Indian Supreme Court.